Good afternoon, everyone. Okay, the dogs are barking. This evening we are going to discuss the laws and legal protections that students have if they are diagnosed with a disability, and that can be a learning disability, physical disability, emotional disability, or intellectual disability. So we're going to go over a few different laws and think of some examples of how those laws work for children and for parents who have whose children have disabilities. Okay, so let's get started. So it's really important to note that under the legal protections of children, I'm going to change my view here a little bit, sorry about that, but where that parents and teachers and students can go to get more information and can go to seek legal protection for students with disabilities. So we're going to be talking about students who are in school, and that is age 3 through age 21. If you have legal documentation, medical documentation, appropriate documentation that identifies you as a person with a disability that interferes, and this is important and you'll learn more about that in the law class, but interferes with your ability to perform up to the level of your peers, which is appropriate. Not to your potential, but to the level of your peers as it is appropriate. So the Office of Civil Rights is one place that parents and students have access to information and legal protection. Their whole purpose is to eliminate discrimination on the basis of disability, any discrimination that occurs against the student with the disability. And it is up to the schools to prove they are not discriminating. It is not up to the parents to prove that the child is being discriminated against, though the parent will file often a complaint to the Office of Civil Rights, kind of outlining what is occurring, and then it is up to the school division to basically counter that. So the OCR, the Office of Civil Rights, receives numerous complaints and inquiries in the area of elementary and secondary education involving Section 504 of the Rehabilitation Act. So as a teacher, you are going to hear the child has a 504, and that means that they have been given these protections under Section 504 of the Rehabilitation Act of 1973. Okay? And now the other legal approach to providing students with accommodations and modifications is under the Individuals with Disabilities Education Act, and that is Public Law 94-142, which came into effect in the late 70s. Most of the concerns that come to the Office of Civil Rights are concerns that deal with the identification of students who are protected by Section 504, and if the child is receiving an appropriate education. So the term appropriate is really important here, and I think that as beginning teachers, you must understand that we all would hope that all children can reach their full potential. However, that is not the charge of public education. You need to kind of look at, every state has a different clause in the state constitution, and you'll go more into this in the law class, but the right to a free public education is not in the Constitution of the United States. It is in each state's constitution, and each state's constitution will phrase it differently. For example, Virginia does afford all children a free and appropriate education. So it's free, and that free is important, and you won't find that in every state's constitution that it is totally free. So there've been a couple law cases in the past just around the free. Locally, in a local county, the students used to have to pay for their textbooks, and they used to have to buy a gym uniform. It started out as a group of parents arguing that they should not have to buy a gym uniform for their children because the state constitution said that education was free. And the court sided with the parents, and they said, yes, the Constitution does say that the public education is to be free to all students. And because health and PE was required as part of the child's education, the school could not require the child to buy a uniform in order to participate in the health and PE courses. So the charge for uniforms went away, and of course, basically what they did is say, okay, you just can wear gym shorts and a t-shirt. You don't have to buy a uniform. So then it trickled down to the textbooks, and students then were no longer required to pay rent on their textbooks. Schools argued that that was one way that they kept up to date on textbooks, but they said that is not the individual child's responsibility or the family's responsibility to pay for textbooks or to rent the textbooks, that the school divisions and the state had to figure out how to keep the textbooks available to the students free of charge. So you'll hear some of those kinds of things, but all of that comes out of this, what we call FAPE, free and appropriate public education. Okay, so a little bit more about Section 504, and we did talk that it is to provide legal protections to students with disabilities to any programs and activities that receive federal financial assistance from the U.S. Department of Education. And this includes all public school districts or divisions, depending on how the state defines their school systems. And that includes sports, because the sports are funded, they receive federal funding. Colleges and universities receive federal funding, so they also cannot discriminate against those students. If you are a private school, and let's say you don't take any public assistance at all, no public food, no public tuition, loans, they don't have to be scholarships, that could be a loan, then really you can basically exclude any student from your school. You are not required to adhere to the 504 or adhere to the IDEA, though I don't know very many schools that have the luxury to do that. So the exact wording, and I will read this to you so that you kind of hear the importance of this message. Under Section 504, and again, this is the Rehabilitation Act of 1973, no otherwise qualified individual with a disability in the United States shall solely by reason of her or his disability be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Now, if we also take a look at how that applies specifically to school districts, because Section 504 can go beyond the public school. And here is where we find the term free and appropriate public education. So it's to each qualified student with a disability who's in the school district's jurisdiction, and Virginia uses the term division, regardless of the nature or severity of the disability. And this statement was included because before deinstitutionalization in the early 70s, after this law was enacted, children were educated in an institutional environment. So their parents were told, your child has a disability, a physical disability, or an intellectual disability. A term that was often used was mental retardation. And the parents were told the child would be better off at an institution to live there. And many parents were told very odd things, such as the child will ruin your life, the brothers and sisters won't be able to deal with it if there were other siblings in the house. It just takes too much time and effort. But then once 504 came into place, a lot of the institutions that house these children, and they included children with high intellectual capability, children with Down syndrome, children with Tourette's, were moved into what were called neighborhood educational settings in their local public schools. So under Section 504, FAPE consists of the provision of regular or special education, and we replace the term regular today with general. So rather than saying regular, we're trying to use a people first language. So we refer to it as general education, right? Because what's regular, what's irregular, right? Or special education and related aids and services designed to meet the student's individual education needs as adequately as the needs of non-disabled students are met. Now, the appropriate and adequately comes into play here. If the child is functioning perfectly fine on their own and making adequate progress along with their peers, then the school is not required to develop a special program. There's a very famous case where a kindergartner, and you'll learn this in law class, a kindergartner's parent said she's not reaching her potential. She could be doing so much better, she's so much smarter if she had an interpreter. And the teacher said she's doing fine, she can read lips, she can hear some muffled sounds, she can read, and it went to the Supreme Court, and the Supreme Court said she is performing at the level of her peers in an adequate manner. And even though we would like all of our children to reach their full potential, that is not the role of public education. The role of public education is an appropriate and adequate education. We often miss that, and parents have a really hard time with that sometimes because they want their child to be pushed as hard as they can be pushed and reach their full potential. But technically, we don't have that charge in any of our public schools for any of our children. But that doesn't mean we can discriminate. So for instance, I'm working with a child now, and he has a 504 plan, but they won't let him take advanced classes. He has average intelligence or slightly above average intelligence. He can handle higher level classes, but they have him in the lowest level classes because the teachers say they cannot provide individual attention for him or accommodations for him. That is illegal. He has to be with his peers. Those would be peers with average or above average intelligence in the same types of classes that his peers are taking. With the supports, he would need to do fine in those classes. It doesn't mean he needs to get all A's, but he does need to be able to function adequately in those courses. So it's kind of a fine line. Okay, so the Americans with Disabilities Act is another legal protection. This deals more, this is Title II, and it deals a little bit more with children once they get out of school, but it does prohibit discrimination on the basis of disability by state and local governments, okay? And schools are a governmental entity, so Title II does fall under some of that. Okay, then we have the Individuals with Disabilities Education Act. And here we have the Office of Special Education and Rehabilitative Services, or OSERS. If you haven't already noticed, there are many, many acronyms in education, and even more in special education. So get used to learning a lot of these acronyms as a new teacher. It kind of takes a while. But if you hear an acronym and you do not understand it, ask for somebody to explain it to you, okay? So we have this Individuals with Disabilities Education Act, and here's where your IEPs come into place. So this is a statute, actually, this education policy, Public Law 94-142, was enacted, and it was started by Hillary Clinton way back early in her career, fresh out of law school. She did a lot to get IDEA off the ground and push through the legislative process. Each state educational agency is responsible for the administration of IDEA within the state, and they must then distribute the funds for special education programs. So the funds for IDEA are directly tied to federal monies. And there are very strict rules and regulations as to the way that those funds can be used. It's kind of a grant statute, and there are many legal strings attached to that. Okay, so if we go back to 504 for a little bit, sorry, I'm moving my face around, making you dizzy. So the services, if we talk about what services are available to students with disabilities under, let's go back to section 504. So it requires recipients to provide students with disabilities, and this, they're talking about the recipients of the monies, to appropriate educational services designed to meet the individual needs of the students to the same extent as the needs of students without disabilities are met. And this is where the debate will often come in. But you have to be really careful as a teacher not to argue that you can not provide students with special needs accommodations or modifications. Now remember, accommodations are things that you do to put the child on a level playing field that do not change the curriculum for that child. So things such as extended time on tests, sitting in the front of the room, a hearing aid, a scribe, voice to text, longer time on assignments, peer tutoring, a mentor, a notebook that goes home back and forth between the parent and the child. Those are accommodations. You haven't changed the curriculum. You haven't changed the expectations. A modification is a change to the curriculum. A modification would be that the student is not learning multiplication this year. The students were continuing to work on addition and subtraction because the student has an intellectual disability but is in a first grade classroom or a second grade classroom and is not ready for that. That would be a modification to the curriculum. So we're talking about accommodations versus modifications. An appropriate education for a student with a disability under Section 504 regulations could consist of education in a general education classroom. The law uses the term regular classrooms, but if we're thinking about people first language, we want to think about the term a general education classroom rather than a regular classroom, right? A special education classroom is not an irregular classroom, it's a special education classroom. Education in general education classes with supplementary services. It might include additional tutoring outside of that class, but it can't be, pulling the child out cannot be in place of that class. For example, my niece, when she was in first grade, they pulled her out of class so much in first grade she missed all of the content. And toward the end of the year, the parents were told, well, she's got to repeat this grade because she missed all the content. The parents like, well, why did you let her miss all the content if you were supposed to be helping her in support services? So there was a disconnect between what the law says and what the teachers did. They were giving her remediation, but they were not keeping her up with the curriculum. And it's a fine line. You've got to really try to work with students with disabilities and understand their particular disability and how to meet their individual need to make sure they're getting equal access to the curriculum in a manner that their general education traditionally developing peers are getting as well. So I can't keep a child out of the classroom to remediate them when they're losing access to all of the curriculum in that grade level. Let's take an example. I'm a biology teacher and I teach in a biology class and I have a student with dyslexia, and the student with dyslexia in my 9th grade bio class reads at a 4th grade level, and my biology textbook is on an 8th grade level, 7th or 8th grades typically. What do I do about that as a teacher? We have a whole class in our program dedicated to reading in the content area. What are and you'll learn a lot of strategies that teachers can use, teachers develop to help those students. Books on tape are a great resource for those students. Khan Academy is a great resource for those students. There's a lot of other types of strategies you can use when a student is not reading up to grade level, but has the comprehension to understand that content. So you'll learn more about that as we go along as well. Okay, the Office of Civil Rights examines incidences in which Students with disabilities are allegedly subjected to treatment which is different from the treatment to which similar situated students without disabilities are subjected. For example, the ninth grader who was kept out of the honors classes, which is the mid-level classes, or even AP classes, because once he had a 504, they automatically dropped them down to the easier classes. And in one meeting, one of the teachers said, when I asked for a writing sample to do an analysis on his writing, she said, well, I don't have them write. I only have them do 1 or 2 sentences because that's really all they can do. Right there, it was obvious there was a violation of his 504 plan because he had average to above average intelligence. He can write a complete sentence. His spelling was not great. He needed help with punctuation, capitalization. He could have dictated probably a paragraph into voice-to-text software in that class, but the expectations were very low, and you have to be really careful about that. Oftentimes, parents have to push and push and push, and teachers become advocates oftentimes for students, especially students with specific learning disabilities, so that they understand the child has a very high level intellectual capacity, and they're being expected to do things that are well beneath what their ability level is. That's where sometimes you're going to see behaviors. That's sometimes where you're going to see low self-esteem. And we'll get into this when we talk about students with dyslexia. Okay? Unwarranted exclusion of disabled students from educational programs and services. So this child, there was an unwarranted exclusion of him from the honors classes. In fact, the mother forced them to put him in an honors class, and the teacher in the classroom said, I don't know why you put him in this class. He can't even keep up with his assignments on Google. It confuses him. And she said, well, he's diagnosed with ADHD and dyslexia. So he needs, in his 504, a notebook coming home. He needs a calendar of assignments so he can keep track of the assignments. And the teacher said, I don't have time to do that. Violation of his 504. Okay, go a little smaller here, ready? Does the OCR, the Office of Civil Rights, mediate complaints? It does not engage in a formal mediation. It basically hears cases and rules on cases. They may offer to facilitate remediation, referred to as early complaint resolution, but that rarely happens. Usually when a parent files a complaint with the Office of Civil Rights, they're at their wit's end. They have tried every other avenue within either the local school board or the state school board, and have gotten nowhere. A mediation process, and I've been involved in mediation in North Carolina and in Virginia, basically is to try to resolve a conflict. And it can be a complaint or a conflict filed under Section 504. It brings the parties together so they may discuss possible resolutions of the complaint immediately. And there's usually a mediator there that understands the law and the ramifications of what has been denied to the child, who will push things along. So for instance, the mediation in North Carolina, this was a few years ago, was with a student who was on the autism spectrum. Highly intelligent, well above average intelligence, into the gifted range, and they would not put him in general education courses. So you can see how that the parents were very upset that the expectations were so low because his social interactions with other children were not what they needed to be. Okay, so students protected under Section 504. They attend schools receiving federal financial assistance. This is kind of a review. They have a physical or mental impairment. Now, dyslexia, all the specific learning disabilities in the DSM-5 are classified as mental impairments. And when we say mental impairment, we're not talking about an emotional impairment here. We're talking about that it has to deal with the way that the brain works. And we know that the synapses in the brains are not in children with dyslexia are different from typically developing children. Okay, and there are some good resources and lectures I'm going to have you listen to as part of this class. They have a record of such an impairment, so it has to be diagnosed by a professional that is qualified, and they have to be regarded as having such an impairment. Okay, so Section 504 requires that school districts provide a free and appropriate public education to qualified students. That's what you need to remember, that the school district or division must provide free and appropriate, and we talked about what's free and what's appropriate. That is a good question on an exam. What is meant by free and appropriate public education to qualified students? What does that mean? And how can you define that? So you probably want to revisit this as you're studying for the final exam. Okay, so what is a physical or mental impairment that substantially limits a major life activity? And this is where the American Disabilities Act comes into play, and it kind of goes over into adulthood, because just because you graduate from high school does not mean that all protections go away. It just means that IDEA is no longer in place, but the American with Disabilities Act is in place, and the Rehabilitation Act also comes into play. Not as much as ADA, but some. Okay, so Section 504 defines physical or mental impairment, psychological disorder or condition, cosmetic disfigurement, anatomical loss affecting one or more of the following body symptoms: neurological, musculoskeletal, and you can kind of read through all of these. And then it gets down here: mental retardation, intellectual disability is the term now, but this is under the law, organic brain syndrome, emotional or mental illness, and specific learning disabilities. Okay, so you can't memorize, do not memorize all of these, but just be familiar. These are some of the things that when you're on an IEP team and as a general education teacher or as a special education teacher, you will be assigned to an IEP team. And sometimes it's for a student you don't even know, but you have to read all the documentation, and you as a licensed professional have to be ready to weigh in on that child's educational program. Okay, what are meant as major life activities? Caring for oneself, performing manual tasks. And these are for more of your adaptive curriculum students, right? Seeing, hearing, speaking, breathing, learning, and working. And there's lots of legal cases that if a child had a trach, could they go to public schools? If a child cannot walk, can they go to a public school? I was at a lecture years and years ago, and this one speaker, she was a mother of a child who could not walk, and they would not let him go to public school. And she went to enroll him in kindergarten, and they were very, very concerned. And she said, he belongs in this kindergarten classroom. It was a general education kindergarten class. She said, he's perfectly fine. All they need to do is move him from, his wheelchair to the floor, or his wheelchair to a desk. And he had a feeding tube, so it's really easy to feed him in his feeding tube. The teacher can do it, right? And there's been legal cases, and teachers do have to help students with those functionings. But the first day of school came, and she went early. She took him into the kindergarten classroom. She put him on the floor on his stomach. She put everything he needed beside him with a long letter. His wheelchair was there, and she left the building. She went home, closed her curtains. The phone started ringing. She did not answer the phone. She waited all day nervously as to what was going to happen. She pulls up in front of the school to pick him up after school, and she said the suits were there. She knew they were going to be there, right? So all these people in suits, the people from central office were there. And she walked up, and they said, he does not belong here. He cannot walk. He said, what if we had a fire, the teachers could not get him out quickly enough? This mother said, since he was born, I've been planning for this transition in his life. And she said to them, if the school is on fire, and there has not been a school or there has not been a fire in the school since it was built 70 years ago. If there's a fire that is that bad and they absolutely cannot get him out of the building, let him burn. And she said this, she said these men just looked at each other. They didn't know what to say to her. She goes, I am not giving up. You are going to educate him. And they realized that, okay, were they going to battle this mother, or are they going to try to make it work? And the teacher said, look, I'm willing to work with this child, and we're going to take him. The principal said, we're going to take him. The suit said, okay, let's go ahead. He went all the way through elementary school. The children, he became their friend. He went through high school. It was a great transition for him into that kindergarten year. But imagine the stress that that mother had to go through. Just because he could not walk and he could not eat like a typically developing child could eat, they did not want him there. So Congress has many, many more examples, and you can go to the Rehabilitation Act of 1973, look up under 504, but it goes into adulthood. Even reproduction is protected under 504, so that you do have to receive assistance in the workplace for fertility treatments, let's say, but that's not really school, but interesting point. Okay, so let's go on. All right. So once the child is identified as eligible, is that student always entitled to such services? Yes, as long as the child remains eligible. So let's say if somewhere along the line the child is keeping up, surpassing, not using the accommodations or modifications anymore, is doing perfectly fine, and everybody's in agreement, then the child can, and the parents can say, the child really doesn't need a 504 plan yet. I caution parents on that, especially before transition years. There are many times when parents in high school will see the child doing okay, because you get to make more choices in high school, right? Do I want to go into a trade? Do I want to go into college level classes? Do I want to go more toward, a nursing type program? And then when they get to college and the pace picks up, or the subject matter is a little more difficult than high school, they were wishing they had those protections of the 504. So for college-bound students, I usually will say, let's just hang on to the 504. You can decrease some of the accommodations. You might get rid of all the modifications, and let's just see how things go the first year of college. Okay. So I'm going to stop sharing. I hope that gave you some information about the legal protections of students. A little bit later, we'll go a little bit more deeply into IDEA, but I think focusing on 504 is enough for this evening, and we'll talk about it in our open sessions. And if you have questions, you're welcome to email me your questions, and I can help you with those, or we can schedule a face-to-face session. Have a good evening, and I'll talk to you all soon.